Hello, my name is Selena, and I will be talking about the Ninth Amendment. The Ninth Amendment is basically the rights retained by the people. It's stated in the Constitution as the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In Supreme Court cases, the Ninth Amendment has been utilized to mean the right to privacy, and has been used on court cases about contraceptives and birth control. The next few slides will talk about some major court cases on this issue. The first case I'll be talking about is Griswold versus Connecticut. Griswold wanted to challenge a Connecticut law that made contraceptives illegal. She brought the case to the Supreme Court, who ruled that birth control was a freedom of privacy under the Ninth Amendment and therefore should not be made illegal. Griswold versus Connecticut is significant because it's the first time the Ninth Amendment was used as the right to privacy in the Supreme Court, thus nationalizing this interpretation of the Ninth Amendment and creating a stepping stone of what's to come. The next case I'll be talking about is Roe v. Wade. So here's a quick rundown of what exactly happened in this case. Roe, a pregnant woman, was challenging a Texas abortion law that denied the right to abortion unless it was life-threatening to the mother. The Supreme Court, when they chose to take up this case, ruled that the Texas abortion law went against the Ninth Amendment and the 14th Amendment, which is the Due Process Clause. Oftentimes during the issue of abortion and other medical controversies, the 14th and Ninth Amendment work hand in hand as the right to privacy. As a result, the Supreme Court made the decision that the states do not have the right to interfere with an abortion procedure within the first trimester. Using the precedent set by Griswold v. Connecticut, abortion was no longer restricted to only those whose lives were in danger. This set a milestone based on the Ninth Amendment. On the other hand, Planned Parenthood v. Casey provided restrictions on abortions and contraceptives, a backward step in progress. Supreme Court kept the ruling of Roe v. Wade, but provided some restrictions. 5 provisions were considered. The informed consent rule, stating that the abortion doctors must inform their patients of the health risks. The spousal notice rule, stating that women must inform their spouses of the abortion. The parent notification and consent rule, stating that minors must gain consent from their parents. The 24-hour hold, stating that patients must wait 24 hours. And lastly, the reporting mandates, requiring abortion clinics to report themselves to the state. The only provision that was struck down by the court was the spousal notice rule, reasoning that it could cause an undue burden on the woman. The issue with abortion is that it causes 2 amendments to clash. The First Amendment, which is used to justify protests, and the Second Amendment, which is used to justify abortions. In the picture on the right, we see a group of passionate pro-lifers in front of an abortion clinic, ready to harass any woman seeking an abortion. Due to issues such as these, the Freedom of Access to Clinic Entrances Act was passed, making it a federal crime to intimidate abortion providers or women seeking abortions. The freedom of privacy has also been used on other moral issues. For example, the issue of parents denying their children a life-saving surgery. 2 cases that were important to this case would be the 2 baby Doe cases. Both baby Doe cases were very similar. Both babies had serious medical conditions and required surgery to prolong their lives, but the parents refused the surgery for their child. When taken to court, the court ruled for both cases that the parents had the right to choose due to the right to privacy. Surgeon General C. Everett Koop was outraged with these cases and did more research on them. He found that there was no reason for any of these babies to be denied treatment when he checked their medical reports, and they were often neglected food and water. He used this information to argue that rather than these babies being denied treatment for religious or moral purposes, they were simply being neglected due to their disabilities. He explained this to Congress and convinced them to pass the Baby Doe Law, requiring states to report cases of medical neglect unless the baby is comatose, or there is absolutely no hope for the baby's survival. Refusing life-saving medical treatment, such as life support, has legally been dubbed as medical suicide, which has created many controversies. In the case of Cruzon versus Director of the Missouri Department of Health in 1990, Nancy Beth Cruzon's parents desired to terminate her life support system. The Supreme Court ruled that while individuals had the right to refuse medical treatment due to the 14th Amendment, or the right to life, the parents were not given that right because the parents lacked clear and convincing evidence that Cruzon desired the treatment to be withdrawn. Because other people are not allowed to prevent individuals from taking life-saving medical procedures, euthanasia has also been dubbed illegal. Just to review, here is a list of important Supreme Court cases that need to be known. Definitely know Roe v. Wade and Planned Parenthood v. Casey if nothing else. Also keep in mind that when it comes to the Ninth Amendment, the 14th Amendment also tends to go hand in hand, while the Ninth Amendment and the First Amendment tend to butt heads, particularly in the case of abortion. Good luck, and remember, Ginsburg is rooting for you. And sleeping. But mostly sleeping.